So at the very beginning, I would like to stress that the topic of my presentation is a part of a much broader project devoted to the philosophy of violence, and I think that this topic is the first idea of it comes across, right, our minds while thinking about philosophical aspects of violence. Of course, besides another very obvious question, what violence actually is, right? What does it mean from a philosophical point of view? So my presentation is going to answer both questions. So what is violence, and what can be conditions, right, that must be met by justified right acts of violence. So my presentation is right. This hand maybe. Okay. So my presentation is divided into two parts. In the first part, I present a few definitions of violence and propose my own moderate definition. It says that violence is the intentional encroachment into the sphere of somebody's autonomy against their will. I explain this definition by analyzing the term autonomy as closely related to the concept of positive liberty. The second part, points 3 and 4, concerns potential strategies of justifying violence. I distinguish two such strategies: in defense justification and out of court justification. First, I analyze them with regard to model cases. That means such cases whose moral justification doesn't seem to be controversial. And then I try to extend their validity to cover some less obvious cases. I conclude my presentation giving two necessary conditions that must be met by any justified act of violence. So, in our attempt to recognize the inherent nature of violence, we should avoid two temptations. On the one hand, to try to delineate the phenomenon from the start very precisely, and on the other hand, to read its manifestation into every aspect of human reality. At this stage, the blind pursuit of detail and precision might be destructive as resulting in framing the research too narrowly. Because of that reason, so-called legitimist definition of violence seems to be of little use in philosophy, since it decides in advance what is the relation between violence and law. The definition claims, in the version proposed by Robert Paul Wolff, that violence is, quote, the illegitimate and unauthorized use of force to effect decisions against the will or desire of others, end of quote. Since the definition makes a normative political element part of the meaning of the term violence, it automatically excludes every military or police intervention from its range. According to that definition, a policeman beating a protester doesn't commit a violence, which obviously seems to be at odds with our general moral intuition. What's more, the definition doesn't even allow posing the question about the legitimate and authorized forms of violence, since in the light of the definition, these terms are self-contradictory. The same problem, consisting in determining too much, too early, seems to plague all narrow or restricted definitions of violence, like, for example, this given in Oxford English Dictionary. It claims that by violence, it is to be understood behavior involving physical force intended to hurt, damage, or kill someone or something, end of quote. Such a definition overlooks many forms of behavior that, although don't resort to force, are clearly violent. For example, verbal offense, threats, and other non-physical forms of coercion. Equally misleading are these definitions that treat almost every form of of interfering into the realm of one's individuality as violent. Johann Galtung has proposed one such definition in his prominent, maybe right now the best known essay on violence, entitled Violence, Peace and Peace Research from 1969. Therein he states in a purely Aristotelian way that violence is present when human beings are being influenced so that their actual somatic and mental realizations are below their potential realizations. According to that definition, violence occurs in every situation where our actual personal development lies below our reasonable expectations. Some could even argue that the institution of marriage, with its oath of allegiance, presents a form of structural violence, since it restricts to some extent the scope of individual somatic experience. However, it was not Galtung who proposed the broadest definition of violence, but Bernhard Waldenfels. To his mind, every order, by its very nature, is violent. He writes that because every order is selective and exclusive, each contains some element of violence. End of quote. I think that such a definition is so broad that it almost verges on paradox. It seems, namely, that it goes so far as excluding any attempt at rationalization and understanding, since that includes conceptual ordering. The definition saying that violence is the intentional encroachment into the sphere of somebody's autonomy against their will seems to avoid both extremes. It is namely broad enough to cover the whole array of types of violence, physical and psychological, personal and structural, manifest and latent. And at the same time, it excludes cases of consensual encroachment into somebody's autonomy, as well as avoids any Galtung's-style perfectionism. However, before I will make use of the definition to explain the meaning of the term autonomy as crucial to its understanding. The personal autonomy, on the analogy to a political state, can be characterized as the sovereignty to govern oneself. Such an understanding of autonomy can be deepened by relating it to the concept of positive liberty as described, characterized by Isaiah Berlin. He characterizes positive liberty by referring to the fundamental human desire to be self-directed. Quote, I wish to be an instrument of my own, not other men's acts of will. I wish to be a subject, not an object, deciding, not being decided for, self-directed and not acted upon by external nature or by other men, as if I were a thing, or an animal, or a slave incapable of playing a human role, that is, of conceiving goals and policies of my own and realizing them. End of quote. In this positive sense, freedom, which I understand here as synonymous with liberty, is not measured by the spectrum of things I shouldn't be stopped from doing. Its size depends rather on how spacious is the domain where I should be allowed to do whatever I think right, whatever I want. The positive understanding of freedom presupposes an equally positive view on human nature. The negative concept of freedom focuses primarily on the absence of restraints, obstacles. The positive one emphasizes the importance of presence of some fundamental human characteristics without which human existence wouldn't be fully valuable. It means that a human being, in order to make use of the positive freedom, must be endowed with some capacities that allow them to be aware of themselves as a self-determining agent and to make informed decisions about the course of their life. How long is the list of so-called autonomy skills? depends on our understanding of a good, valuable life. The more substantial it is, the more abilities should be needed to make it achievable. I propose to opt for a purely procedural understanding of a good life, which assumes that it is a model a person finds best on basis of their actual knowledge, desires, and expectations. Under such a proviso, the list of autonomous skills could be roughly sketched as follows: introspection, memory, imagination, perception, reasoning skills, second order volitional skills as described by Frankfurt, self-respect, which I've been talking right now about. What many authors are not mentioning in that context, but what seems to me a very important autonomy skill, is exactly self-respect. That characteristic can be considered a kind of meta-rule that makes all other skills workable. Without self-respect, namely, I would discredit all my opinions, evaluations, and plans, and rather trust another person than myself when it comes to governing my life. So without being endowed with self-respect, I suppose all other skills wouldn't be able to provide us with really enough resources for conducting a happy, valuable life. Although autonomy skills are distributed in the population very unequally, we treat autonomy as a right characterizing each and every man to the same extent. In order to make our position consequent, we have to opt for the threshold conception of autonomy as presented by Daniel Wickler, quoted by Joel Feinberg. According to that conception, I quote Joel Feinberg, above a certain minimum, competence is possessed in equal degree by all who have it, no matter how much they differ in degree of competence in other sense. End of quote. So, for example, if being mathematically skilled were tested on the sum 2 and 2, all people, except some marginal cases, would have been considered equally talented in mathematics. The same is true about the qualification for an autonomous being. Since it is enough for a person that a person possesses the autonomy skills only in a minimal degree, most adults who are not suffering from debilitating pathologies or are under oppressive and constricting conditions should be counted as equally autonomous. The above conception of autonomy limits the requirements put on an individual for being autonomous to the minimum. It is neutral with respect to value claims, since it assumes that there are many models of a good life, which are mutually exclusive. Such a pluralistic stance can be defined as the view, I quote Isaiah Berlin, that there are many different ends that men may seek and still be fully rational, fully man, capable of understanding each other. End of quote. That means that the way of life one exhibits gives us never the right to interfere with their choices, not to mention any use of force against them. If somebody's model of life doesn't appeal to us, the only available way of influencing their life is by referring to the same basic procedures that constitutes their autonomy, to rational persuasion. Then the spectrum of possible violations of so broadly sketched autonomy seems to be relatively wide. It embraces not only physical aggression, violence against the body, but also various kinds of coercion, violence against choices, and also different forms of offense, violence against dignity. The classification of violence, these aspects are not right, or maybe it should be rather expressed in such a way that right, a violent action can manifest many of these aspects. Right. So these types of these aspects of violation of autonomy should be treated right as different characteristics of a violent action. In some cases, all of them can be combined together in one action. For example, act of rape. It is right physical aggression, it is coercion, and it is surely an offense. Sometimes there can be present only one of these aspects, like for example in the case of humiliation. One question is worth precising before we will proceed to the next part. Is it namely necessary that every act of violence embrace the dignity aspect? Putting it in other words, does every act of violence constitute an attack on somebody's dignity? In my opinion, the answer to that question should be negative. There are namely cases of violence whose function is not to discredit somebody else's dignity, but rather defend one's own dignity. For example, slap in the face as a reaction to somebody's obscene behavior. In the next part, I will argue that there can be, or that there can be morally justified only those cases of violence where no dignity aspect is involved. Violence can be justified by using two approaches, deontological and utilitarian. I don't consider them contradictory, but rather complementary. However, I place the deontological justification above the utilitarian, since the former is directly related to the victim as a moral individual, and the latter is detached, as formulated from the point of view of an impartial observer, considering what would maximize utility. Right. In favoring the deontological strategy, I'm following Thomas Nagel's postulate that whatever one does to another person intentionally must be aimed at him as a subject with the intention that he receives it as a subject. That maxim that results from the Kantian categorical imperative expressed in material mode implies that no action whose intention is not directly related to its subject can be morally justified. According to this position, no moral justification can be provided for treating a person only as a means for achieving benefits by another person or group of people, even if the latter's benefit were significantly bigger and more intense than the victims suffer. Ascribing priority to the deontological justification doesn't mean, however, that the utilitarian one is here of no use. It seems namely fully rational to accept a particular kind of action on the ground of deontological principles and to justify the details of its execution referring to the utility calculus. Helping another person is always morally appreciated. However, the way we do it, if it has been done efficiently, effectively, can influence the final assessment of the deed. So, while searching for conditions that could make us accept some acts of violence as morally justified, we will focus first on the relation aggressor-victim, and later on other individuals and groups who, in the result of this violence, could benefit or suffer damage. Following Nagel's principle, I consider morally justifiable only those cases of violence where the victim is directly related. I distinguish two fundamental contexts where that is the case: in defense and out of care context. The model case of the first context is violence exercised in self-defense. When a person, for example, is doing physical harm to the aggressor while defending themselves. As regards the second out of care contexts, the model case is parents' paternalistic behavior toward their children. Since both model cases seem to be intuitively morally justified, they can be used for recognizing two universal strategies of justifying violence. Both can be applied not only to the aforementioned model cases, but also to some derivative cases. First, in defense justification. Jan Narveson, in his essay Criticizing Pacifism, writes that, quote, "If a man threatens to kill me, it is desirable for me to try to prevent this by the use of the least amount of force sufficient to do the job. But I am justified even in killing him if necessary." This much, I suppose, is obvious to most people. End of quote. Such a direct self-defense that is aimed at stopping an attack is so intuitive that the opposite cases are classified under the heading of heroic sacrifice, martyrdom, or simply mental illness. But how can such obvious case of self-defense be morally justified? I think that there are two possible justifications of such a conduct: aggressor-oriented and victim-oriented. The former has been formulated by John Locke in the second treatise of government, where he writes that I may destroy a man who makes war on me or has revealed himself as an enemy to my life for the same reason that I may kill a wolf or a lion, because such men are not under the ties of the common law of reason, have no rule except that of force and violence, and so may be treated as beasts of prey, dangerous creatures that will certainly destroy me if I fall into their power. End of quote. Following Lockean train of thought, it could be even said that such self-defense is not violence at all, since it doesn't violate the aggressor's right to autonomy. They have relinquished the right at the moment when they decided to assault me. The other justification of self-defense, victim-oriented, can be found in the aforecited essay by Narveson. According to him, it would be senseless to ascribe a right to somebody who wouldn't be at the same time granted with the right to defend it. The right, by its very nature, is something I am allowed to rightfully defend using all necessary means. As Narveson writes, the right to resist is precisely what having a right of safety of person is, if it is anything at all. End of quote. Does it mean that a person who doesn't defend himself while being attacked relinquishes their right to autonomy, analogously to the former aggressor-oriented cases? I don't think so. The person rather doesn't understand which rights they have or what it means to have rights at all. Defense of another person. If the case of self-defense can be morally justified, then it is to be expected that justified is also the case of using violence in defense of another person. If it is namely justified that a person can use violence in self-defense, it should be also to help a person who is not able to fight back against the attack alone. Such a situation can be considered to be the act of granting some physical capacities to a person who, being devoid of them, would otherwise inevitably suffer harm. Thereby, it is even our obligation to step in and to protect the person from the aggressor. If we didn't intervene, it would amount to deciding on somebody's behalf of their safety, which seems to be flagrant usurpation. In some countries, like for example in France, there is even provision for criminal liability for omissions in the failure to provide help to a person suffering from particular kinds of transgressions. The above considerations seem to be useful for sketching an answer to the question if torturing can be ever justified. Let's imagine a classic thriller movie scenario. A boy has been kidnapped. The abductor states the boy has been put into a coffin and buried in a place known only to him. There is not much time left. Soon there will be no more air to breathe in the coffin. Are we allowed to torture this man in order to get the information where the boy has been buried? The situation could be equated to the above case of coming to somebody's rescue. We are inflicting the perpetrated harm in order to help the boy. If we had done it at an earlier stage of the crime, while the boy, for example, was being attacked and put into the trunk of the kidnapper's car, our intervention would have been also violent, but in a bit different way. So it could be claimed that torturing is a special case of using violence in defense of another person, which is particular because in a way postponed. There must be satisfied, of course, two important conditions. There should be no doubt. We must be 100% sure about the identity of the perpetrator. And the second condition, the use of physical violence should be the last possibility of getting information required for rescuing somebody's life. If there are other possibilities, we are morally obliged first to use those possibilities. The second context is out of care context. It is obvious that parental care cannot forego ordering, and forbidding. Parents must assist their children since they are not fully knowledgeable and very often get overwhelmed by emotions that can threaten their safety and health. Both intellectual and emotional aspect gives parent rights to interfere with their child's choices and correct their behavior. Such paternalism doesn't trigger any controversy unless it results to inflicting corporal punishment. Then it could be argued that such harsh paternalism is affecting not only child's choices, but also their feeling of self-respect. In such a situation, paternalism would miss its point, which is to assist the child in shaping their autonomy and not to undermine it. Since adults are considered to be able to make use of their autonomy by themselves, it seems to be difficult to apply to them the same strategy as to children. But it is not entirely true, since also adults are susceptible to getting distracted or overwhelmed by some emotions that make it impossible to them to rationally evaluate their position. If it happens in our presence, it is our obligation to restrain the person, even by force, from risking their life or simply making a mistake. For example, the Thracian woman, instead of laughing at Thales, should have rather saved him from falling, either by shouting at him, or just by holding him back. There is no doubt that the intervention would be morally praiseworthy. However, some authors, like for example Joel Feinberg, call into question the paternalistic character of this deed, of such a behavior. And it is not without reason, since it doesn't seem that in this situation, Thales' autonomy was violated in any way. While daydreaming, he wasn't autonomous at all as regards the path he was walking. He wasn't acting at all in regard to the dangers on the path. He needed protection from something that wasn't exactly himself. That's the argument by Joel Feinberg. If that is the case, such a quasi-paternalistic behavior doesn't seem to require any justification at all. This consequence can be interestingly applied to a very particular kind of paternalism that on the one hand influences our choices, but on the other hand operates below the threshold of consciousness. As it modifies decisions that we aren't even aware of taking, it doesn't seem to constitute any threat to autonomy. This kind of paternalism has been called libertarian, since no coercion is involved, and was described by Richard Taylor and Cass Sunstein in their article from 2003. Then it was discussed in detail in their bestseller, Nudge, Improving Decisions About Health, Wealth, and Happiness from 2008. The libertarian paternalism doesn't impose on us a particular decision, but rather arranges our environment in a way that increases the probability that we choose the most beneficial option. The small features of the environment that might influence our decisions have been called by Taylor and Sunstein nudges. Nudges. We create nudges by using choice architecture, as for example by designing a cafeteria. We decide to arrange the food in such a way as to promote those meals that are health beneficial and to make difficult to get to the junk food. Nudging seems to be an optimal version of paternalism since it is proactive and autonomy friendly. But the problem, right, up to this moment, paternalism hasn't posed any challenge to justification. The problem with the justification of paternalism appears only when we ask about permissibility of overt coercion as a means of changing somebody's behavior. Such a kind of coercive paternalism was fiercely criticized by, of course, fiercely, by John Stuart Mill, who On Liberty writes that the only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. His own good, either physical or moral, is not a sufficient warrant. He cannot rightfully be compelled to do or forbear because it will be better for him to do so, because it will make him happier, because in the options of others, to do so would be wise or even right. End of quote. Mill's criticism, however, can be undermined because of two reasons. First, it is based on the false assumption that everyone knows best what is good and bad for them. And second, it doesn't distinguish between the paternalism of ends on the one hand and the paternalism of means on the other. People might know what their ends are, but still make mistakes while deciding how to get them. Sarah Conley, the author of the book Against Autonomy, Justifying Coercive Paternalism from 2013, claims that the fact that people are often biased and don't have enough specialized knowledge gives us the right to interfere with their decisions if they clearly contradict those people's long-term ends. So, assuming, for example, that long and healthy life is the fundamental end of all people, we could not only justify nudging them to have a better diet, but also forbidding them to buy some sort of unhealthy food, as it unsuccessfully tried to do New York Mayor Michael Bloomberg, putting forward a motion to ban selling Coca-Cola in larger cans than 16 ounces. So, in the case where citizens' behavior endangers their vital ends, the state is allowed to step in and to impose on citizens some regulations. And actually that is happening. We are required to fasten our seatbelts while driving a car or wear helmets while driving a motorcycle. However, Conley postulates to go much farther. Her most controversial claim is that because the health risks of smoking are so serious, the government should ban it. She claims that, quote, sometimes the only way to stop someone from making a terrible mistake is to intervene and prevent him from choosing freely. End of quote. I suppose that hardly anyone would consider such a harsh paternalism justified. But this is, of course, open question. So, conclusions. The above analysis don't exhaust, of course, the whole diversity of violent behaviors. Nothing has been said, for example, about deterrent violence and preemptive violence. Nevertheless, I have presented general lines along which it could be attempted to justify a violent action. At this stage of research, I formulate the thesis that a violent action is, in order to be justified, must meet two necessary conditions. The first condition is that the action must be directly related to its victim. If the victim is directly related, can be tested by trying to formulate the intention of the offender without any reference to the victim as a subject, that means to their interest and intention. If it is possible, then such an action does not directly relate to the victim. The concept of directly relating intention to the victim comes from Thomas Nagel. So, if we behave violently to a person, our intention to do so must either result from previous intentional actions of that person, for example, self-defense case, or must result in the future benefits for that person out of care case. The second condition is that the violent action shouldn't ever target personal dignity. It should be restricted to what concerns human behavior and never undermine somebody's self-respect. Every encroachment on the personal feeling of dignity should be always considered as excessive violence and hence as intolerable. And that's it.